Good day everyone, my name is Jason Salon Kibod, third year student with Criminology Section D. So this video I'm going to report Chapter 3, the Provision Law of the Philippines, Presidential Decree number 968 as amended by RE 10707. Philippine Provision Law. So what is Provision Law or what is provision? So provision, it is the privilege granted by the court to the person who are convicted in criminal offense to remain in the community instead actually going to jail or prison. So uh, ang provision daw is usa ka pribilehiyo nga gihatag sa korte didto sa tao nga convicted sa criminal offense nga magpabilin gihapon sa community instead nga pagadalon sa jail or sa prison. On July 24, 1986, 1976, Presidential Decree number 968 was promulgated. This law applies to adult convicts and first-time minor drug offenders. By virtue of RE 9165, particularly Section 70. So, kani daw siyang balaod is kasagaran ma-apply sa mga adult convicts and first-time drug offender. So the law, which is more popular known as the Comprehensive Dangerous Drug Act of 2002, and Child in Conflict with the Law or CICL under Section 42 of RE 9344 of the Juvenile Justice and Welfare Act of 2006. So bali, Comprehensive Dangerous Drug Act of 2002 ginaingon provides importation of any dangerous drugs and control precursor and essential chemical. And also it established the penalty and offenses according to the different dangerous drug. So bali kani daw Comprehensive Dangerous Drug Act of 2006 o 2002 mao na siyang nag-establish or nagamugna sa penalty or sa mga penalty or sa mga kiniang offenses na sa mga nakalapas sa paggamit sa mga delikado nga nahisgutan nga mga droga. So however, PD 968 was subjected to amendment for another statutes. These mandatory laws are as follows. So number 1, Presidential Decree number 1257, effective upon issuance on December 1, 1977, amending Section 47, Paragraph 1, 15, and 33 of PD 968. 2. Batas Pambansa BLG 76, effective upon approval by the President on June 13, 1980, amending Section 9 and of PD 968. 3. Presidential Decree number 1990 or 1990, promulgated on October 5, 1985, and took effect January 15, 1986 after 15 days from the date of its publication in the official gazette. December 30, 1985, this law amended or amending Presidential amended Section 4 and 9 of PD 968. 4. Public Act number 10707, an act amending Presidential Decree number 968 as amended. This act, which is a consolidation of Senate Bill number 2280 and House Bill number 4147, was passed by the Senate and the House of Representatives on September 15 to September 14 to 2015. It is approved on November 26, 2015 by President Benigno Aquino III. So bali kanido siyang act is muna siyang nag-uban or nag-uban sa Senate Bill number 2280 and House Bill number 4147 nga gipasa dito sa Senado o balay sa mga representante dadtong September 14 to September 14, 2015 o kini siya ginapurbahan ni President Benigno Aquino III dadtong November 26, 2015. Next is number 5, Republic Act number 9344 or the Juvenile and Welfare Act of 2006. Amended Section 4 of PD 968 to read as follows. Section 42. Provision as an alternative to imprisonment. The court may, after it shall have convicted and sentenced a child in conflict with the law and upon application at any time, place the child on probation in lieu of service of her sentence, taking into account and the best interest of the child. So bali ang korte daw kuno human kini ma-convicted or mas magsintensya sa usa ka bata or sa child in conflict with the law. So kini do siya mahimaw mag-apply sa bisan unsa nga oras og ang bata pagadalon kuno sa probation. Isip puli sa iyahang serbisyo sa iyang sentensya o ang isipon lang ang pinaka best or pinaka maayo nga interest sa bata. So for this purpose, Section 4 of Presidential Decree number 968, otherwise known as the Probation Law of 1976, is hereby amended accordingly. So when we say Probation Law of 1976, ginaingon dito no na no person shall be placed on probation except upon prior investigation by the probation officer and the determination of the court that the ends of justice and the best interest of the public as well as of the defendant will be served thereby. So bali ginaingon wala daw ay tao nga ibutang sa probation gawas sa unang investigasyon sa probation officer nga ang determinasyon daw kuno sa korte nga ang ang katuyuan sa hustisya nga ang pinakalabing maayo nga interes sa publiko ingon man usab niini ang defendant nga paghatag pinaagi niini. So other laws prescribing disqualification for probation. So mao po ni siyang lain nga balaod nga nagprescribe nga disqualification siya para sa probation. So number 6, Omnibus Election Code of Philippine Batas Pambansa BLG 881, disqualification for probation, even the penalty of imprisonment is within the coverage of PD 968. So section 264, which is penalties. So ginaingon no, any person found guilty of an election offense under this code shall be punished with imprisonment of not less than 1 year but not more than 6 years and not shall be subjected to probation. So ginaingon bisag kinsa daw kuno nga tao nga ma-found nga guilty sa election sa bisan unsa nga election offense under the nga code, so siya daw kuno pagapanisan sa pagkapriso sa dili daw kuno moubos sa usa ka tuig ug dili pud siya molapas sa unom ka tuig ug siya dili siya masubject to probation. So number 7, Wage Rationalization Act Republic number 6727. So section 12, any person, corporation, trust, firm, partnership, association or entity which refuses or fails to pay any of the prescribed increase or adjustment in the wage rates made in accordance with this act shall be punished by a fine not less than 25,000 nor more than 100,000 pesos or imprisonment not less than 2 years or not more than 4 years. So bali ginaingon no, bisag unsa daw kuno nga tao or mga corporation, partnership o association na kini ang nagdumili or napakyas sa pagbayad sa maong ilang gi-prescribe nga pag-increase o pag-adjust sa sweldo nga gimugna daning kini nga balaod. So siya daw kuno pagapanisan sa multa nga 25,000 dili po daw kuno mo taas sa 100,000 ug sa pagkapriso dili maubos sa 2 ka tuig ug dili pud ako molapas sa 4 ka tuig. So next is number 8, Comprehensive Dangerous Drug Act of 2002 or Public Act 9165. So section 24, non-applicability of the provision law for drug traffickers and pushers. Any person convicted for drug trafficking and pushers under this act, regardless of the penalty imposed by the court, cannot avail of the privilege granted by the provision law. So ginaingon no, sa kinsa daw kuno nga tao nga convicted sa drug trafficking and pushing, so under the ning act sa penalty nga giimpose sa korte, so siya daw kuno dili makaabil sa pribilehiyo nga gigarantiya sa provision law. So however, section 57 and 70 RE 9165 requires the applicability of the provision law. So provision and community service under the voluntary submission program. So section 57, provision and community service under the voluntary submission program. So when we say voluntary submission program, it is an intervention activity whereby the drug dependent and any person who violates. So a drug dependent who is discharged as rehabilitated by DOH accredited center through the voluntary submission program but does not qualify for exemption for criminal liability under section 55 of this act may be charged under the provision of this act but shall be placed on probation and undergo in community service in lieu of imprisonment and a fine or the discretion of the court without prejudice to the outcome of any pending case filed in the court. So bali usa daw kuno ka drug dependent nga gi-discharge o gi-rehabilitate sa DOH pinaagi sa voluntary submission program, pero dili daw siya ma-qualify sa exemption for criminal liability under dani siya nga section. Siguro ma-charge siya sa provision but mabutang gyapon siya sa provision ug i-undergo or maipailawom siya sa community service, police sa iyang pagkapriso and or fine discretion of the court. So bali sa iyang pagkapriso or sa iyang pagkamulta nga ang gabuot ang korte nga walay pagpihig nga resulta sa bisan unsa nga kaso daw kuno nga napinding nga gi-file sa korte. So number 10, provision or community service for a first-time minor offender in lieu of imprisonment. So section 70, provision or community service for a first-time minor offender in lieu of imprisonment. Upon promulgation of the sentence, the court may, in its discretion, place the accused under the provision even if the sentence provided under this act is higher than that provided the existing law on probation. So bali ang minor daw kuno nga edad makasala, so ipailawom daw kuno sila sa community service instead nga sila pag-aprisohon. So bali ang korte daw kuno is naghatag og pabor sa accused tungod kay ang accused is ginabutang sa provision bisan tuod og ang kining even if the sentence provided under this act, so bisan to katuod og kato kanang sentensya nga gina-provide ani nga balaod is mas dako pa kaysa kasamtangan nga balaod sa provision law. So that's all and thank you.